All right, pending before the court is a motion for a mistrial made pursuant to 15A-1061 of the North Carolina General Statutes. This motion is premised upon, or the basis of this motion is rulings of the court, specifically a ruling relating to the last objection and the sustaining of that objection relating to hearsay in the transcript of the defendant's statement made on April 23rd, 2013. With respect to that, I find that this ruling, and to the extent it's premised on other rulings that were recited by counsel, I find that this motion is premised upon rulings of the court, which in the court's view is consistent with the law of North Carolina, both under statute, Constitution of North Carolina, and Constitution of the United States. Each of the rulings that I've made have been made with the opportunity for counsel to be heard. The court has carefully reviewed, listened to the arguments of counsel, considered those arguments, and rendered the ruling that the court believes is in accordance with the court's understanding of relevant law. So for that reason, I find that the conduct referenced by counsel in support of the motion for mistrial, I do not find that rises to the level of an error or legal defect in these proceedings or the conduct inside or outside this courtroom that would result in substantial and irreparable prejudice to the defendant in this case. And so the motion for a mistrial is denied. Now, with respect to the motion for recusal, this motion is brought under North Carolina General Statute 15A-1223, parens B, parens 1, which requires recusal when there is prejudice against a moving party in favor of the adverse party. Mr. Arbor has cited a number of reasons that he believes that I, as the judge in this case, ought to recuse myself in this matter. Recited in his motion was the fact that I required the trial to proceed forward despite the defendant not having his beard shaved, that I limited questions to the jury, that I denied a motion for cause with respect to the jury, that I denied a motion relating to the same transcript that we're talking about under Rule 106, again, that I limited or that I denied prior motions for mistrial. I denied the right, denied that I required Mr. Arbor to refer to his clients in questioning of Mr. Wallace, and as a general rule, by surnames as a matter of decorum. And now finally, this last series of questions regarding limitation on the answer of the limitation on introduction of the answers of Mr. Broyhill into the trial of this matter that were derived from the interview of April 26, 2013. Now, with respect to this matter, the first question is whether this ought to be referred, whether this motion ought to be referred to another judicial official for determination of whether I ought to recuse myself from this case. I would find with respect to that, again, this motion has been premised on the prior rulings of the court, and for the purposes of this motion, assuming even if all of these allegations were true, that would not require recusal. In my view, rulings of the court that are objected to and disagreed with perhaps by counsel for the defense would not rise to the level of, even if taken as true, which the record will reflect what my rulings were, that would not require recusal of a judicial official. I further would find that the allegations as stated in the motion lack sufficient force to require referral of this matter to another judge. I find that the record fails to demonstrate objectively that grounds for disqualification actually exist, and I find that the motion lacks substantial evidence that might reasonably call the judge's objectivity into question. And so for those reasons, the motion to recuse is also denied. We'll proceed if we're ready. If there's anything else we need to be heard on, that'll be fine. We'll do that. All right. Yes, sir.
Defense renews then, in light of the court's rulings, it's a motion to have the interview of April 23rd, 2013 introduced, where the state introduces a portion of a confession. We respectfully again say, and I don't think it's disputed, that the state indicated in its argument against admitting it the other day that there are a number, like he said 7, and I believe there's more, references to the prior interview on the 23rd in the one that was admitted for the 26th. They are connected. Where the state introduces a portion of a confession, the defendant is entitled to have the entire confession admitted and considered by the jury. State versus Barnwell 17, NC App 299, 194, Southeast 2nd, 63. There is an exception if the matters are irrelevant and prejudicial. Specifically, Your Honor, he makes specific reference in the 26th interview to an amount of money referenced by Mr. Broyhill in the interview of the 23rd of $20,000. That amount does not come out of thin air unless you have the interview of the 23rd for the jury to consider. If they're not allowed to consider that, then they're not going to know where that came from. And you've allowed the interview of the 26th into evidence. So to not permit this is to be in violation of State v. Barnwell by permitting the state to introduce only a portion of the defendant's confession in this case. All right. So we renew our motion to have the interview of April 23rd admitted into evidence.
All right. Well, let me point out, Mr. Arbor, that this is a new motion that is a specific motion. It is seeking, the prior motion you made was to introduce the entire motion, the entire interview. There is a difference between that and now saying there is a passage of that I believe is admissible. And so I'm going to consider that on its merits. I think that in my prior ruling, I discussed what the defendant's burden was with respect to a Rule 106 motion. And in my ruling, I indicated that burden had not been met. I'm going to treat what you've asked for as a new motion, now asking for a specific excerpt of the prior interview to be admitted into evidence. And I'll hear Mr. Fawcett's view on that, and I'll make a ruling on a new motion. But I have seen nothing thus far that would require me to change my ruling with respect to the introduction of the entire transcript as was the subject of the original motion. And if that's your motion now, I'll stand by my ruling, but if you're asking at this time to be considered an excerpt that you believe is directly relevant and is required under Rule 106 or for some other basis, then we can talk about that. Is that what you're asking for?
I'm asking for the entire confession to be played for the defendant. Any excerpt is not the entire confession.
All right. And
because
that motion,
all confessions
right,
have to be taken into consideration in light of the entire circumstances in which a confession is received. A jury is allowed to consider the way a confession is received. That includes such things as how the person's condition is at the time that they're making the confession. It includes the questions that were asked of the person leading up to the time that they make that statement, because it creates a context for the jury and how they determine that that response was given. And to limit it only to a specific question would be to deny him his due process rights to have, and the ruling in Barnwell, to have the entire confession submitted. What I will do then, Your Honor, is I will try to honor Your Honor's over our objection ruling to get through the interview of the 22nd. And if it comes a point where the state doesn't want a jury to find this stuff out about how he received this information, I guess he'll object and you'll make a ruling and we'll proceed from there.
All right. Then if you're not asking for an excerpt, then I won't consider a hypothetical motion.
I may at the end, but I'm making a motion right now that the entire interview of the 22nd be admitted for the jury's consideration and we would offer it into evidence at this time.
Okay, and I've not heard anything that would change the ruling that I made previously. No further grounds have been provided to me for allowing the what has been deemed to be hearsay into evidence in this manner, namely during the state's case, offered by the defendant in the state's case. I'm standing by the previous ruling that I made with respect to Rule 106. Mr. Fawcett, anything else you need to be heard on, sir?
Judge, no, thank you.
All right. Anything further, Mr. Arbor? All right, very good. Let us do this. Let's go ahead and just take a 15-minute recess. And Madam Bailiff, if you'll just inform the jurors that we're taking a 15-minute recess. You know, it's my practice to inform the jurors or remind the jurors of the rules each time prior to a recess. I will be happy to bring them back into the courtroom unless counsel agrees that we can dispense with that on this occasion. Do you want me to bring them back in the courtroom to remind them of their rules, Mr. Fawcett? Do you wish to be heard on that?
Do not, no.
All right, Mr. Arbor?
I would ask them to be brought in.
Okay, let's bring them in. I'll give them a very brief recitation of the rules and send them on a recess.
Yes, sir.
Right, ladies and gentlemen, as I described to you early in this case in my remarks to you, from time to time matters come up that the law requires us to consider outside the presence of the jury, and I ask you not to speculate or on those matters. Again, these are matters that we are required to consider outside the presence of the jury. I'll simply say that the objection is sustained, and we are going to take a recess. And we're going to break for about 15 minutes. So I brought you back in primarily just to simply let you know that we're going to take a 15-minute recess, so feel free to go get a cup of coffee or whatever you wish. And please recall all the rules and instructions I've given you. Don't talk among yourselves or with anyone else about the case. Don't form or express any opinion about the outcome. No media or independent investigation into these matters. And please have no conversations with parties, witnesses, or lawyers. If you'll gather in the deliberation room at 20 minutes till 12 and leave your notepads in your chair. Everyone else, please remain seated. And again, outside the presence of the jury, are there any matters that we need to take up before we recess?
Not from the state, Your Honor.
All right, very well. We'll be in recess till 20 minutes till 12.